Doing this every week on Tuesday from 5 p.m. to 6 p.m. Central Time, we're bringing immigration updates. Emily, what do we have today?
Today we want to talk about the continuing saga of these long pending PERM processing. The labor certification is taking forever. We're still only getting approvals for cases that were filed back in September 2022. So we're looking at 11 months processing time. What can we do to speed things up? What have we done? What are we hoping to accomplish? And we've got one of our partners, Stephen Brown, with us to talk about that today. We're also going to talk about the text message that USCIS sent to thousands of people about the medical exam. Green card applicants, please send us your medical as soon as possible. What does that mean? What do you need to do about it? What if your date's not current? What if you don't have an RFE? They seem to be sending it to everyone. We also want to talk about switching from using the H-1B for your work authorization to using the EAD that comes with your pending I-485. And if you do that, how does that impact your dependents' non-immigrant status? How does that work with reentry? Can you get back to H-1B? So we'll go over those issues that keep popping up. And then last, what happens if you have your H-1B approved, but you lost your job? What are your options? How can you get back to H-1B in the future? What plans do you have, whether this is a cap subject H-1B or an H-1B that you've had for some time? So getting back to the PERM process, as I said, we're seeing approvals now for cases filed 11 months ago, and those are ones that were not audited. And this has just gotten longer and longer and longer since probably October 2020. I feel like this has been an ongoing issue. So we wanted to bring in Stephen Brown to talk a little bit about what we're seeing in the delays. What have we done up to this point? What kind of data did you get? And then what are we doing with that data?
Yeah, definitely. So, this kind of brought to my attention on the PERM side. So I manage our firm's litigation side, and it was brought to my attention at the beginning of the year, just that it's gotten incredible. I think DOL posted on July 31st that they're up to 311 days for their processing. What's interesting is in 2002, when the PERM regulation was first proposed, they were expecting to do this in 21 days. The final regulation said, hey, we'll do it in about 45 to 60 days. That's a long way off from 311 days. What's interesting about PERM and PERM delays is, unlike any of the delays with USCIS, all of the data is readily available. The Trump administration trying to shame these companies for sponsoring people, put together all of the PERM data. It's publicly available on Department of Labor's website. What we ended up doing is trying to work to theorize and come up with some ideas on litigation. And because we had this data, we engaged an expert statistician. I think he's worked on some political cases with the ACLU on congressional lines, to go through the data and tell us, what does the data tell us from a delay standpoint. It's very interesting. We ended up also doing a FOIA, Freedom of Information Act request for audit procedures, audit and audit data, so we can kind of make the data sets from DOL better. And it's kind of interesting what we got that's publicly available. So one, it's not a funding problem. They actually have record funding for the OFLC for $83,810,000 is the funding for OFLC. And there's not been a significant increase in the number of cases. I think I did the math this morning, and assuming I did it right, I think they're only getting about $7 less per case than they were in, say, 2020, which isn't substantial to lead to the significant delays we're seeing now. So we filed. We actually ended up filing a lawsuit today on the PERM delays for a number of individual plaintiffs. Looking at this data, and again, this is an interesting case in my opinion, because in a lot of the delay cases, right, we have to make allegations. We allege USCIS doesn't adjudicate 485s on a first in, first out basis. We allege that they take people out of the line. We allege certain things that we know to be true between us as attorneys, people, everybody knows this, but we don't have the data readily available to support it. With this case, we know we have this data. Our statistician's telling me that the standard deviation is about 33 days. That means, the cases are kind of in a month-long. It shows a highly variable adjudication process. There was also data about how many times you would likely to be skipped, right? So if you file on a Monday, I don't have the number in front of me, but it was a significant number of times that you would be skipped in the line for people that filed after you. And I'm not talking about, if Emily files her case on Monday, I filed mine on Tuesday, I get an adjudication before Emily, like that. Okay, that might happen, right? It shouldn't, because the whole PERM process is supposed to be computerized, but that might happen. We're talking about month-long gaps between some cases that were filed after. So I think it's a very interesting lawsuit. We filed this in Atlanta, where a lot of the PERM adjudications are being done. We did it for a number of individuals. Kind of our analysis is that the individuals are in the zone of interest in this, right? Not on the PWD side is a little bit different, the prevailing wage, because that's not tied to you as an individual. But once you file that PERM application, it's got your information on it, right? And so we think there's a lot there to show that the individuals are in the zone of interest. And ultimately, individuals are the ones getting hurt. I mean, we've got people that are rest of the world that are wanting to apply for green cards. We got people that are having 5-year L1 issues, 6-year H1 issues. Their spouses can't work. They might be running into a 6-year issue and can't plan with their family, with kids going to school in the future if they've got to leave. There's a lot of harm these delays cause, and it's something that, again, DOL originally thought it was going to take 21 days, then settled on 45 to 60, because it should be a computer doing it outside of audited cases. There's no reason for it taking 311 days. So I'm not going to take a lawsuit that I don't like. So I'm not just going to sit there and say I like this case. Obviously, I do. I filed. We filed it, but the data is so key in this case, and I'm loving it.
So, Stephen, let's say I'm a client, and I'm nearing 6 years of H-1B. That's my crucial thing. And I filed my labor certification. You're telling that labor certification should be adjudicated within 60 days according to the Department of Labor regulations, is that right?
Yeah, man. Remember,
and then everybody knows that it's taking more than 300 days. So let's agree to the terms that it's taking 311 days. So if I'm a person and my 6th year is expiring and my company is not going to, once I leave, they may not continue with my labor certification I-140. So what is the typical timeline that I should come once I file the labor certification to the court? Because you said that the Department of Labor is, according to the regulations, will take 45 to 60 days. So we know that when it's 45 to 60 days, it's 60 days, not 45 days. So let's assume that it's 60 days. When should I go to the court? And what is the timeline that I'm expected to get any response once I go to the court, though?
Yeah, so I think each case is going to be unique, right? So each individual, right, it's going to fluctuate based off of what the harm is, right? If you're facing a 6-year issue, your harm might be a little bit different than, hey, I just want my wife to get, my spouse to get an H-4 EAD. I mean, I want to see it pending at least that 60 days, right? Because I want to cross that threshold. But what's reasonable is going to be kind of individual specific. We have a very interesting strategy on how we're going to take this case in court. We're going to look to not let them play games and kind of be aggressive on it. I don't want to go too much in detail, but we have a plan that we're going to kind of move to try to get to the end of the case quicker than the normal 60 days that it takes for the government to respond to a lawsuit.
In other words, typically when we file a lawsuit against USCIS takes 60 days to respond to that. Mm-hmm. You're telling that there is something that you're working which you may force the Department of Labor to respond do it lesser than 60 days. Is that what you're
Yeah,
telling me?
that's the strategy we have.
Okay. And, litigation, court litigation, that too, federal court litigation, filing a case in front of a judge who's appointed by the President of the United States, ratified by the Senate of the United States, that requires a lot of money, does it? Or is it like when you're filing for clubbing of individuals, will I get a discount?
Yeah, so this first case that we're doing, I mean, we're doing it as a group case. We kind of took it in a way to try to lessen the cost by doing it. And I think some cases are good as groups. I think some cases are not as good as groups. I think here, we have indisputable facts, right? The data is coming from Department of Labor. Where now we have a statistician who has interpreted that data, but the data is not in question. It's the Department of Labor's data.
And you're telling that it may, there is a chance that it may take shorter than 60 days for us to get a response. Of course, there's no guarantees when we go to the court litigation, though. So do you expect some retribution? People have fear when you go to the court against the government is going to come in the night and pick you up. Is that true?
No. So, it's a common question we get, and I get the fear, right? And maybe some places that might happen, but here you are fighting.
When you say some places, you mean to say in the United States or in Iraq?
Not the United States.
North Korea.
No. But here you are fighting for your rights. You're not violating any status, and it would be unlawful for them to retaliate against them. And I've talked to plenty of attorneys who used to be government attorneys, and they've made it expressly clear to me that they never had a client saying, "Hey, we want to take an action against this guy that's suing us for a delay." That never even crossed their desk.
And Stephen, labor certification is filed by the employer, not employee. Now, so when we want to file, when an individual is getting near to the 6th year, does the employer has to approach for you for the green card for the litigation, or can the employee also approach for the litigation?
Yeah, I mean, I'd be happy to do it for an employer. Nothing wrong with that. What we kind of found is that individuals, they're the ones that are getting harmed. They're the ones who want to take this on. And we think that there's plenty of case law out there that would allow us to have the individuals as plaintiffs because they're in that zone of interest here.
Of course, you can't guarantee that you're going to get positive relief. There's no guarantee in that thing.
No, of course not.
What if you get shot down in the court? Does that mean that my labor certification will be denied, or will it be in the normal processing line?
Yeah, no, definitely. So another common question we get with any litigation. No, I mean, worst case scenario, if the judge says this is the worst lawsuit I've ever seen, and I'm going to sanction you, and you're never going to practice law again because of how bad this lawsuit is, it doesn't impact your DOL case. It would continue in the normal course, kind of as a worst case scenario.
Can you give us an idea of kind of some of the harms the plaintiffs in this lawsuit are facing, and kind of what you brought into the complaint?
Yeah, so I actually found this case very interesting. We had a very diverse group, not all around the world, a lot of different issues that are causing, but we've got, people that are about to hit their 6-year limit. They want to seek their green card because they're a rest of the world applicant and they want to be able to take advantage of that. Or we've got a plaintiff who is current, but has left that employer and is needing this PERM in order to file for the I-140 and 485, even though their priority date is current. We've got people that just want that security, right? You get that PERM, you get that I-140, and you're on a new playing field for your immigration journey. Even if you're from a backlog country, it opens up more opportunities. You have more stability once you get to that stage.
And with the plaintiffs that we've got in this lawsuit, how long typically have their PERMs been pending? Is there a range?
I didn't run it. I'm looking here at my complaint, 5 months, 7 months. We've got some that are right at that 60-day mark. Let's see here, at least 6 months. I mean, again, longer than that 60 days that they thought. And again, that 60 days is interesting because when you have regulations, that's an interpretation of what Congress intended, right? And so when DOL says, hey, we want to do this in 45, originally 21 days, and then settling on 45 to 60 days, they're basically interpreting it that, hey, that's kind of what Congress wanted us to do. When you look at AC 21, and that's kind of what we lead off with is AC 21, and AC 21 wanting to ensure that delays don't disrupt the supply of high-skilled immigration lawyers. And, you know, one of the biggest, high-skilled immigration immigrants, one of the biggest hurdles right now, other than the visa bulletin, right, is DOL. I mean, no matter what the visa bulletin says, if DOL is taking a year to do the PERM, and that doesn't include PW, the prevailing wage, which is a problem, or then the 60 day, the recruitment, and then the dead periods and all that. If they're taking a year just for that last step, that significantly slows down the process for people.
So if someone is, facing the delay in their PERM and, they're nearing their 6-year limit, or their rest of world and their date's going to be current and they can't file 485 or things like that. Now that you've filed this first lawsuit, are you able to add additional plaintiffs? Are you going to file more lawsuits? Can people still get involved?
Yeah, so we've got a Telegram group for the DOL PERM delay. If shoot me an email, I'm happy to get you that as the case, kind of develops into future cases or amendments. Right now, our goal is we want to focus on this group and kind of see how this goes. It's kind of new suing DOL, right, on delays. I, again, have a lot of faith on this, but I don't want to, I don't want to expose too many things here until we see how it's going to go. But I feel very good about the case, and I hope, well, I would say I'd hope DOL fixes it here, of course, but if not, let's go. We're ready.
Yeah, so you're definitely no stranger to these immigration delay cases. I mean, you were at the forefront of filing delay cases with the H-4 when they started separating the applications and requiring these biometrics and all of that. And thanks to your work, USCIS now has to bundle all the H-1B and the H-4 together, and they eliminated or suspended the biometrics requirement. And you filed a lot of delay cases for I-485s, for EAD AP delays. So all of that, and even Department of State, right? So this is kind of new filing with DOL, but it's kind of the same premise. So under the Administrative Procedures Act, which says that a government agency has a duty to act within a reasonable period of time. And so we argued that they were not acting reasonably when they delayed H-4 EADs, when they were delaying 485s, when they're delaying the GC-EADs and the APs for people who can't travel. Department of State issuing these 221Gs that last for years. So we're kind of taking that same background and applying it to the Labor Department, as the data clearly shows they've just gotten longer and longer and longer, to the point where at some point it has to be unreasonable.
Yeah, and I think, like you said, I mean, I actually filed a 485 case just this afternoon, but I just think this case is so unique. We've never had this much data at the outset. We've asked it, we've created data, right, using data that we have available. But I mean, DOL's got go look at their website. They've got all the PERMs going back to 2014 readily available in a nice little Excel sheet for each quarter, and it makes it a little bit interesting that we know they don't go on a first in, first out, and we've always seen it, right? We've seen cases that are, we got this one approved, but still some pending from September. But we've got that data that shows it, and we've got the line jumping, because that's always this weird thing. Judges like to think that, this is just going to line jump. Well, USCIS does it already. DOL certainly does it. But here we've got that concrete data to show and an expert statistician who's done this analysis. I mean, we did a lot of investment into this case to build it, to see if there's anything there before we brought it. And so it'll be an interesting case to see, and we'll be keeping updates going.
Steven, any of your plaintiffs have the age out issues for the kids though?
I believe so. I've got to double check. I believe we do.
That would be a good case to argue in front of the judge though.
Yeah.
Well, and I think this is a very nice case to bring into the judge, because the harms are very clear. They're not theoretical harms. You know, it's very the 6-year limit's a hard limit. The not being able to file a green card's a hard rule, right? You've got to go through these steps. It's very clear harms that our clients are facing.
Anything else, Steven, before we go to the next topic?
No, thank you. And feel free to email. I'm happy to send you the link to the DOL. We've got a Telegram group just kind of focused on that, and as well as our firm one that, you know, we're happy to kind of address any questions on.
Thank you, Steven.
All right, thanks, y'all.
Emily, with regards to the text message that we are receiving right now, a lot of people who have subscribed to the USCIS and their 485 is pending, even if the priority date is current or even if the priority date is not current, they are receiving a text saying that this is the exact message what they're receiving it on the text though. Message from USCIS: green card applications who receive a request for the form I-693, which is a medical, should return it as soon as possible by overnight priority or courier delivery. If you have already responded to USCIS, then please disregard this message. What to do? People who have filed the 485 priority dates are not current. Some people have already submitted the medical. Some people already got the RFE and submit the medicals. Do they need to panic and submit the medicals right now?
No. So this really should have been geared only to the people where USCIS actually has an outstanding RFE sent to someone and has not received the response back yet. So if you have not received an RFE, but you got this text message, you don't have to do anything. It does not mean that USCIS has sent an RFE. It just means that if they sent you one, respond back quickly. But just because you got the message does not mean you're getting an RFE or they've already issued one. Same thing if you have already gotten that RFE and already responded to it and you're getting this text message now, you don't need to take any action. They're not saying that they didn't get your medical. This is just a blast email that they sent out to everyone in the universe with a pending 485, whether their date is current or not, whether they've had an interview or not, whether they have an RFE or not. So probably 99% of the people that got this text message can completely ignore it. So the only people that have to take action are those that actually, at this moment, have a request for evidence for the medical exam and have not responded to it yet.
And they don't have to respond to them in a priority courier delivery, though. They can always respond slowly. No hurry for them either. If you get if your RFE is already there, definitely this is I consider this as a technical error from the USCIS. The reason is they don't hire the talented H-1B people to work for them. That's the only reason that I can think about. If they hire one of our guys, they know that they shouldn't be sending this kind of message to everybody. Either they don't, technically they're not good, or even if they are technically good, they don't understand the subject knowledge. Somebody pressed a wrong button and everything blasted out. They should hire some H-1Bs that these people should not be allowed to press those wrong buttons to send all these texts though. But yes, you know, the restriction of the USCIS and the federal government in hiring the H-1Bs, there is some restriction. That's the reason they couldn't do the proper programming.
Yeah, the State Department needs to do that too, because I don't know if you've been hearing all the issues with the new visa application and paying the fees and scheduling an appointment. That whole system is apparently a mess. No one can get through it. So they need to get, if this is what they're doing with technology, they need some new, I don't know, they need some help.
They need H-1Bs.
Exactly.
They need H-1Bs to work on. They need to take the limitation on the H-1Bs.
Or let them get the green card so they can actually help.
Employ. Then they're US workers. They can employ them. Yeah. Yes. Stop counting the family members. That's probably better so that they can give more green cards. so that these H-1Bs can do programming for the USCIS and State Department, so they don't have to go through all these hassles. Anything else, Emily, before I go to the next topic?
Nope, next topic.
A lot of people are considering switching to GC-EAD, Emily, because now they got the digest that it may take a long time for them to get the green card. As we have seen in 2007, it took all the way to 2012 to get the green card. For those people who filed the green card in 2012, it took all the way to 2020 to get the green card, 1920 to get the green card. So now people have now digested this, it's going to take a long time. It's very hard to keep the H-1B. And they want to move to the GC-EAD. What will happen to their dependents if they're outside the country? If they have moved into GC-EAD and the dependent is outside the country and does not have an advance parole to come back?
Oh, yeah, good question. I don't think they have a way to come back. So, because obviously if you are no longer maintaining your H-1B status, then your dependent is no longer eligible for H-4. So you definitely need to take that into consideration before you make that switch. Now, there is a way for you to get back to H-1B if you have switched to the GC-EAD and your employer is willing and you're able to continue the terms and conditions of your H-1B status. You can get back to H-1B, but always a good idea to think about that. Think about the dependents before you switch, and if they are outside the U.S., make sure that they have an advanced parole already that they can come back on, because once they're outside the U.S., they can't file an advanced parole once they're out. And if you filed it while they were here and they left while it was pending, you can't use that advanced parole to come back on, even if it gets approved. So yeah, that's a big thing people need to be aware of.
Emily, I just want to go over with regards to the advantages and disadvantages of moving to the GC-EAD. One of the main advantage of moving the GC-EAD is it's easier to get a EAD extension. There is no geographical limitations where you can work. If you want to move from, let's say, California to Texas, you absolutely don't have to file any amendment. If there is any small changes in the salaries, that's not a problem. If there are some small changes in job duties, that's not a problem. You don't have to file any amendment. The cost of filing the EAD extension is zero, really. Of course, lawyers may charge their own money, but the filing fees is zero. You don't have to provide the end client letter, vendor letter, whatever not, you don't have to. There's no filing fees. And even if your EAD extension is not approved, under the current limitations, you can work up to 540 days after your EAD expires. So there are many advantages. So there may be some disadvantages. One main disadvantage, what I feel, Emily, is that the advance parole is taking a long period of time to get an approval. So if your advance parole expires and there is some emergency for you to travel outside the country, you will be limited in traveling. That's the main disadvantage that I see. Of course, there's a solution for it. Stephen Brown was here explaining about the PERM delay. He also sues USCIS on the advance parole delay. You can always contact him. You can file an advance parole and wait for 60 days. And if it doesn't get adjudicated, contact Stephen Brown so that you can try to get your advance parole approval faster. That's one major disadvantage that I see for those people who are on H-1B contemplating on to moving into GC-EAD. Anything else, Emily, before we go to the next topic?
We can move on. So what happens in the situation? So I guess we'll start with like a cap subject H-1B. Someone got selected in the lottery this year, already filed the H-1B, already got it approved, and now they've lost that job. Do they have any options? Do they need to go back to OPT? Can they go back to OPT? Should they? Or is there a way to save that cap number so they can use the H-1B with a new employer?
There are two scenarios, Emily. If the company does not withdraw the H-1B until October 1st, though, then the solutions are that the person can find another job within 60 days from October 1st. Because the H-1B
from October 1st.
Yeah,
60 days from October 1st.
That's right. Because the 60 days of grace period starts on October 1st. This person is. So 60 days from October 1st, he can find another job to file the H-1B application. That will be a transfer of H-1B application from company A to company B. So in that way that he is preserved for the H-1B and he can move on to a different company. That would be the best case scenario. The second case scenario would be that the company withdraws the H-1B before October 1st and the company receives the confirmation that the H-1B has been withdrawn before the October 1st only. In that case, he can take the withdrawal confirmation that the USCIS has sent. He can take that to the DSO and show it designated student official, and then they can do a data correction where they can reinstate into the service system because his H-1B was withdrawn before October 1st.
And this is for someone who still has time left on their OPT for them to get
That
back
is
to
right.
OPT.
You are absolutely right, Emily. For those people who are not on the cap, who have some time left on the STEM extension or on the OPT, they can go back and correct. It's called data correction. The problem here is, Emily, that when companies withdraw the H-1B, they may not get the confirmation before October 1st. So that's where the problem is. For the people who get the confirmation before October 1st, they're good. They're technically not counted toward the H-1B. They can always go there and they can actually get their data correction. They're in good shape too. Now, here comes the third set of people, and that's where most of the people fall into. The company withdraws the H-1B before October 1st, and they don't get the confirmation until October 1st. Now, I just want to greet all my fellow Indians. It's a happy Independence Day for you guys. But when it comes to this situation, third situation, I have to speak a Hindi proverb in there. I don't have anything in English, so I have to speak this in Hindi. When the H-1B is withdrawn and the confirmation is not received by October 1st, though, that's where the problem comes in, is that what to do at that point of time? Can they apply for the H-1B? Can they get the H-1B? Can they not? Can they actually be excluded from the H-1B? Can you answer the question for me? I feel that I have to tell that sometimes they may be na garka, na gatka, but you go ahead and explain it.
Yeah, so what I see happen quite often is, the company has sent the withdrawal, which should stop the H-1B from taking effect on October 1st, but USCIS doesn't acknowledge that withdrawal until after October 1st. That means on October 1st, you've changed status to H-1B and your F-1 has been terminated. Usually your SEVIS record will be complete at that point. And it sometimes takes months for USCIS to issue the confirmation of withdrawal. And during that time, you're completely in limbo because you are not technically in F-1 status because your SEVIS has been complete, but you're technically not in H-1B status because you're not working for the employer that got your H-1B approval. And so you're just in limbo for weeks and weeks and months on end. And a lot of times people end up having to exit the U.S., apply for a new school, or come back on another F-1, and they lose out on the remaining of their OPT or STEM extension. So if there's, especially as we're getting closer and closer to October 1st, if you're facing a job loss situation now, I would highly recommend trying to work with your employer to ask them to not withdraw until after October 1st, because that gives you the ability to keep that H-1B and file a transfer to a new employer using the 60-day grace period versus trying to get back to OPT, because we know that processing time of USCIS to respond to the withdrawal is probably going to take longer than October 1st if they're sending out a withdrawal today, August 15th. I mean, we're getting, we were joking in the office today, we got a stack of I-485 withdrawal, I-140 withdrawal confirmations that we mailed out, or the companies mailed out during the Obama administration. We just now are getting confirmation from USCIS.
You're speaking before 2016, Emily.
Yeah, it's ridiculous.
Are you sure?
Yes. I mean, my name is on them, and I don't file that type of case anymore. So it's been around. They're old cases. So yeah, it's a very tough situation to be in. And if at all possible, if you can save that cap number, obviously you know how hard it was to get through the lottery this year. So that is a huge advantage if you can get them to wait until October 1st to withdraw. The company's not losing anything by doing that. They're not violating anything. I've reached out to companies on behalf of people from time to time. Because, they're saying, no, the law requires us to withdraw it today. Otherwise, we're going to be in trouble. That's a violation of LCA rules and a violation of H-1B rules. No, it's not, because the H-1B hasn't taken effect yet. What are they violating if an H-1B hasn't started? They just need to notify USCIS once the H-1B takes effect. They can do it right on October 1st. That ends all of their liability for LCA violations or for back wages or anything like that. There's no harm that comes to the company for delaying submitting this type of withdrawal for a CAP H-1B.
Especially when you're in a situation where you lose the job and you're in the cap, especially from now on to October, we definitely recommend that you contact a lawyer. There are many alternative options that you have: Plan A, Plan B, and Plan C. You need to be prepared for all three things, and also keep your designated student official of your university on loop, so that if there is any action required, you may take their help also to get it done. Anything else, Sandy, before we go to Q&A?
Nope, I think we can take the questions now.
Questions from Santosh Chada. Are H-1B holders allowed to do day trading in stock market? Absolutely no problem with it. You can do it. Now, this is only immigration advice, guys, not a financial advice. You take your own financial decisions.
Jagan wants to know about all the talk about employment-based green card categories becoming current in the October visa bulletin. We're talking about the filing dates chart here. And he asks whether this is likely to occur. I'm definitely not holding my breath on it, although I would love to see the dates become current so people can file the 485, get the EAD, get the AP, take advantage of AC-21, take on new jobs, have their kids' age locked in. There's so many benefits to it. At the same time, you know, what the congressmen are asking for is to make the dates current when we know there's only 140,000 green cards available, and open it up to potentially 700,000 people to file the 485. More than that, because what we do know is there are about, at least as of last March, 700,000 approved employment-based petitions where no visa number was available. The green card, those are the backlog. So if we allow all those people to file in October, plus their family members, because the family members are not counted in that 700,000, there's clearly more people filing than visas available. It would be very hard for the government to say that green cards are immediately available, and that is a requirement in the statute passed by Congress for people to file the 485. Again, I'm not against this. I would love to see it happen. I just question,
I read the law a little bit
something that can legally be done? And on top of that, how can USCIS possibly handle all of that work? And are they really going to be renewing the EAD and AP for a decade, more than a decade, for free for all these years? So that's where I kind of feel like they're not ready to take that step yet. Maybe they'll advance it further than they normally would, but I don't see them making it current in October.
I see a little bit differently, Emily. Well, there are numbers available because there are 140,000 numbers available in October of 2023 because the financial year starts. They can read the law that way. Have they done the employment authorization for millions of people, at least 1 million people previously? Yes, they did. Remember the DACA thing, what the Obama administration did just before they left? They did that provision though. Now, yes, is there a financial gain for the USCIS for it? I think so that they should reintroduce EAD filing fees. If they were to allow these people to file the 485 application, I would give them a bribe by telling, hey, you know, why don't you start charging EAD and advance parole fees? In that way, our guys are satisfied and the USCIS is satisfied too. I believe this administration is a little bit very good administration. When they wanted to do something, Emily, they do it. Even if the people are clinging on to the aircraft, catching on to, they're flying in the aircraft, not inside the aircraft, but on top of the aircraft, on the tire. They still left Afghanistan though. So yes, there is a possibility here. We should, 56 congressmen are supporting it. I would like to support it and you want to support it too. I read the law a little bit differently. The numbers are available because on October 1st, there are 140,000 green cards available. So let's do it right now. They did it in 2007. Remember that? In 2007, they did it current for everybody. And of course, they didn't have enough green cards at that point of time, so they continued with those things until now. So they did those things. So I think so that they can do it again. That's my way of thinking. Now we'll see in October 1st what goes on. But either way, Emily and I will be fighting for you to have this thing going on. Irrespective of the practicality will be different, but let's see if it goes through.
All right. Visafal says, I applied to renew my I-131, that's the advanced parole based on the pending 485. The applications with the Texas Service Center and processing time is 18 months. Ridiculous. Can anything be done litigation-wise? Absolutely, yes. You can reach out to Stephen Brown, stephen@rnlawgroup.com. He files these cases all the time because that processing time is unreasonable. And they can't expect you to sit around for 18 months if you have a need to travel.
Ravi is asking, may I know the current month of the PERM processing by USCIS? PERM is processed by Department of Labor, and that is September right now of 2022, not 2020. It's 2022. It's almost 11 months right now to adjudicate the labor certification application. Please remember that. Before filing the labor certification, the company has to get a prevailing wage, and the prevailing wage is taking 8 to 9 months. And after the prevailing wage, then they have a recruitment to be done, and then they file the labor certification. The entire processing time from the scratch to get the I-140 approval, assuming you're going to go in premium processing I-140 approval, is more than 2 years right now. So please, for those people who are contemplating, oh, I'm going to file a labor certification in my 5th year or 6th year, please don't do that. You may want to do the labor certification as soon as possible. Even if you get the H-1B approved in the lottery right now, and then the start date is October 1st, can you start the processing right now? Absolutely, you can. You don't have to wait for the H-1B to start. So please don't delay it, because if you delay it, you need to go with Stephen Brown. If you don't, you may avoid that. It's not that Stephen Brown is a very nice guy, but it's unnecessary expenditure. Try to get it done as soon as possible.
All right.
My employer wants to delay my GC process. How to handle the situation? I think so. You should change the company. I mean, if your skill set are in demand and then your employer is delaying it, change the employer. IT is in the highest demand right now.
Anil says, any update on the H-1B visa stamping within the U.S.? It's supposed to be here by the end of the year. We haven't heard any news that it won't happen. And so I do think they are on track to get that implemented by the end of this year. It may be limited to a smaller group of people based on certain characteristics, but we should get that going soon, hopefully.
Ramakrishna Reddy, multiple registrations in the first lottery for no job offer, so dropped from filing. Nice thing. But the second lottery got the job offer from a legitimate employer. Tough choice. I am telling them, Emily, to file the H-1B because it's from the legit employer who is not involved in any way of filing the multiple H-1B applications, though. Here is the reason what I think so that why. Let's say he's working with Coca-Cola company, and then he filed with 5 or 7 or 10 different H-1Bs with multiple registrations, though. The wrongful act has already been done by this individual, though. But we know that Coca-Cola was not involved in any way whatsoever with this individual or with any of the other, colluded with any of the other companies in filing it. So Coca-Cola company should file the H-1B for this individual because they don't have it, they didn't do anything wrong at any point of time. Now, as far as the individual is concerned, though, this person can still be harmed at a later date when he goes for the stamping, because if the State Department finds out that this person colluded in filing the multiple registration, they may bar him. Now, that may happen even if Coca-Cola files the H-1B, even if the Coca-Cola does not file the H-1B later on when he files the H-1B with either Coca-Cola or Pepsi or Verizon, he may still get locked out at the consulate at a later time. So I am telling the people, if it's a legit company, has no involvement and has never filed for multiple applications for other people, to proceed in filing the H-1B. What's your opinion, Emily?
Yeah, I agree. It's the employer that submits the registration. An employee has no way to force multiple employers to submit their registration. The company submitted that, and they did not collude with the legitimate company in any way. So I think they can go ahead with it. I think that USCIS is more focused on the employers that have submitted the same group of names amongst themselves. So that's kind of what we're seeing, at least right now, in terms of notice of intent to revoke, notice of intent to deny. That may change in the future, as USCIS is definitely throwing a lot at trying to enforce the registration process and root out the fraud and all of that sort of thing. But I think as of now, it's relatively safe to go ahead with that.
Question from Crew West. My name is Pavan. My question is, my PERM got approved with company A. I'm with company B. Can I have the company A file the I-140 based on the PERM with the company A? Absolutely. Even though you're not working for the company, can the company A file I-140? They can. And if they are willing to file it, go ahead, file the I-140 application. Please refer that company to other people. So that's such a nice company doing a favor to you and filing an application I-140 even if you're not working. They can, absolutely, they can do it.
Babula says, when can we file for the 7th year H-1B extension? Is it before 365 days of the PERM being filed or after? So you only qualify for that 7th year extension after the PERM has been pending for 365 days. But the H-1B can be filed up to 6 months in advance. So if you already know you're going to qualify, if assuming your PERM is still going to be pending by the time you're hitting your 6-year limit, you can file that now. You don't have to wait till day 365 to actually file the PERM. I'm actually working on a case right now where the 6-year limit is coming at the end of September, and we're not sure that the PERM is going to be approved in time based on when it was filed. So the individual is going to exit the U.S., but we're filing the I-129 now for the H-1B with a start date that we're requesting exactly 365 days from the day the PERM is filed. So we're getting that filed now so that it can be approved now, and he can schedule his visa interview, get the stamping done, and come back faster rather than waiting until day 365 to file. Now it's going to take another month to get the H-1B approved, another month to get the visa interview, another weeks to get the stamp and come back in. So you can speed that up by filing in advance, but the start date can't be earlier than day 365.
Yeah, a lot of people are still panicked with regards to the text message again, guys, from the USCIS. Don't, you're good. Try to watch our video that we did today from about 15 minutes to 25 minutes. We have given the details of that thing, though. Emily, what's the time to submit the second, if I'm selected in the H-1B lottery the second time, what's the time to submit the H-1B?
I believe through October 31st.
October 1st or October 1st? September 31st, 30th or October 1st?
I thought it was at the end of October.
Okay.
Let me see if I can pull up a registration notice.
Okay, no problem.
Mine are all filed, so I haven't really paid attention.
Okay. Can the company A file my I-485 even if I move to company B? Yeah, if the company A wants to file the 485J supplement, they can, even though after you move to company B, we don't see that as a problem. We have filed so many people like that. Sai Sunil has this question. I-140 has been approved by my company. They're not sharing the I-140 approval. What do you do about it? Well, you can file something called Freedom of Information. Can you note it down, please? FOIA, USCIS. You can go online, fill the information out. It takes only 10 minutes. It's online, and it does not cost any money. It takes only 6 weeks for you to get it. Go ahead, do it. And your employer won't even come to know that you filed this I-140 under the Freedom of Information.
Let's see. Mekazor 1913 says, my wife lost her job. She finished her 60-day grace period and traveled to India and came back on H4. if I apply for an H-4 EAD, can she work on the EAD receipt notice? No. So the only auto extension that works for the H-4 EAD is if she's filing an extension of her H-4 EAD. Since she was, I'm assuming, on a different status like H-1B or L-1 before, and now she's filing her first H-4 EAD, there is no work while that EAD application is pending. So she might want to consider coming in to file the EAD application. She can leave while it's pending, work for the company abroad until the EAD gets approved, and then she could come back in to regain her U.S. work.
Only after 6 months of work company will start. Give me 1 second.
Nitin says, I got my H-1 transferred to a new employer and it's been approved for 3 years. But the H-4 was included with it, but somehow something happened and it wasn't received. The current H-4 is still valid for another 2 years. Do I need to reapply for the H-4 using my new employer's H-1B? So that H-4 does remain valid until it expires 2 years from now, even though you switched employers. So technically you don't have to file an H-4 extension right now. The main reason we always recommend filing an H-4 extension along with an H-1B transfer is so that everybody will end up with the same expiration date. So in this case, she's fine. She can stay in H-4 for the next 2 years as long as you're continuing your H-1B with this new employer. But don't forget that her H-4 expires a year before your H-1B, and forget to file her extension or forget to have her go for stamping. But yes, it's fine for her to use that existing H-4 if you'd like.
Raj Ramaya, I got my H-1B concurrently filed H-1B receipt notice. I'm working with company A and company B. I'm trying to take a vacation to Mexico. Can I come back and continue working with the concurrently filed H-1B though? You would have to refile the concurrently filed H-1B every time you go outside the country though. That's a condition where in the I-94, they only issue one company. That's the reason why we tell people not to travel if you have concurrently filed H-1B.
Kay says, I transferred my H-1B recently from company A to company B. If I move to company B now and then the filing date becomes current, can company A still file my 485 application? That's really going to depend on company A and whether their job offer is still open to you. So it's not current employment that qualifies you to file the 485. It's an offer of employment that you'll take when you get your green card. So if company A is still offering you that position and you're still willing to take that position when you get your green card, you can file the 485. Company A has to sign the supplement J, so you can submit that with your 485. But you don't have to be currently working for the company to file the 485. That being said, many companies have a policy that they will not allow you to file the 485. They won't give you that supplement J if you're not currently working for them. So you'll need to understand that and maybe discuss that with your company before you leave them to see if they'd be willing to allow you to file. But we had a number of people that did that in October 2020 when everyone was kind of taken off guard with how far the dates move forward and the ability to do the downgrades. And many people were able to file with their old company and eventually went back to the old company after filing the 485.
Can I file the EAD and advance parole for the 485 pending? Can I file it online? No, unfortunately, you cannot file it online. You have to only file it in the regular mail process.
Ravi has a son who's a Canadian citizen but missed the green card as a derivative because he aged out. And now he wants to come back to the U.S. on a TN visa. But he's also got an I-130 filed in the F2B category, and he wants to know if that's going to be a problem for the TN. It definitely can be. So with the TN, if you're a Canadian, do not have to file anything with USCIS. You don't have to go to the consulate to get the visa stamp. You actually apply at the port of entry with CBP. So when he's coming into the US, the TN is not a dual intent visa. So he needs to establish that when he's entering right now, his intention is to come to the US temporarily to work on the TN, and then he will leave at the end of the TN. Having that I-130 filed or pending could work against him on that. The officer could assume that he has that immigrant intent, but it doesn't mean it's not the only factor they look at. So if your son is going to maintain a residence abroad that he has no intention of abandoning, if the I-130 mentioned that he will consular process rather than file adjustment of status, he can point to that. So there's a number of things he needs to show his ties to Canada and can basically convince the officer that on this trip right now, he has no intention of immigrating. Maybe in the future he will, but if he does want to do that, he will exit and apply at the consulate.
I have filed my wife's and my EAD and AP together, but my wife's EAD and AP combo card got approved. Mine did not get approved. Can I travel to India based on my pending advance parole? No, you cannot, because it's only your wife that got the approval for advance parole. You have to wait for your advance parole before you travel outside the country.
Terrence says, does the SOC ONET code on the LCA play a big role when porting the H-1B from employer A to employer B? Yes and no. So if your question is, does the SOC code with employer A need to be the same as the SOC code with employer B for the transfer to be successful? The answer is no. So each company can be offering you a different job under a different occupational code as long as you have the educational background to qualify under either code. Now, does the code itself play a role in the H-1B adjudication? Yes, because if your employer selected a code that the Department of Labor has said, this job does not normally require a bachelor's degree, you can do this job without a degree, that is taken into account in determining whether your job offer qualifies as a specialty occupation, which is the requirement for an H-1B. Specialty occupation means the job normally requires at least a bachelor's degree in a specific field of study. So in that way, the code has an impact on the transfer, but switching codes between companies has no impact.
Mohan has this question. He got a H-1B with the exempt employer, like the university, for example, where they don't have to go to the lottery system. He's asking, can he work for a concurrently H-1B? That means a private company, for-profit company. Can he work on top of working for the university? Can he concurrently work for a cap subject H-1B? The answer is yes, he can. As long as he's working with the university and the cap exempt, at the same time he wants to work for Microsoft or ABC Consulting Inc. on parallel concurrently, he doesn't have to go through the lottery system. He can concurrently work. Can he leave his main employment and go to the private company, for-profit company, and work on H-1B? No, you cannot. But concurrently, if you want to work, you don't have to go through the lottery system.
VN says, I got the EB-1A approved in June 2023. I'm a UK citizen, but born in India. And I received the email from the NVC to start the process for immigration, but my priority date is not current. Can they process the visa? So the National Visa Center and the State Department actually goes by the dates of filing chart to start the process for consular processing green card. So if your date is current or close to being current under the dates for filing chart, yes, you can start that process, and then they will get all of the preliminary work done so that by the time the date is current, they're ready to approve. Now, if your date is nowhere near the date for filing chart, then maybe they haven't figured out yet that the date's not current, but you can still begin the process if they sent you the email and the instructions.
Agastya has filed the first PERM application in November of 2022. It's not applied. Now, the company is getting acquired. There is a lot of layoffs, and he actually have a plan. He has already applied for a Canadian work permit. Assuming that you get laid off, though, most probably the company is not going to proceed with the I-140 application. But assuming that there is not going to be a layoff in that particular section where you are at, can the new company, which is acquired, the new acquired company, can they file an I-140 based on the labor certification filed by the previous company? The answer is yes, they can. They can file an I-140 even though acquisition happened. 99% of the time they can.
All right, looks like we're out of time for today. Thank you everyone for joining us. We'll be back again next week on Tuesday at 5 o'clock Central Time. And don't forget you can sign up for our newsletter at rnlawgroup.com. And if you want to schedule a consultation, if you have further questions, you want to go over your specific case in more detail, you can schedule a consultation with us or any of our attorneys by going to rnlawgroup.com.
Thank you very much for tuning.